go on paying the debts of the son. In one case, client came to me several times, come but from very affluent family. Ultimately, the father was required to declare that he has disowned his son. Going in club, going in pub and several nothing doing that months and taking loans, that was the only business of the son. Father was required to publish in the public notice with a very heavy heart saying that, I disown my son. Public notice, how people will come to know. Though it may not be sometimes binding, but if the people feel that, see, in our country we still father. Particularly from our generation, you will find that still feel that, reputation is very important. If the debtors of this particular son come at the house of the particular father, father will never say, don't come to me, unless he has a very thick skin. So therefore, my friends, this is also one of the board where he can issue a public notice. I told you, my friend, these three notices. One more notice, three more personal notices. There may be legal notice, what we call it. Whether law, that does not mean others are illegal, but it's a legal notice. It's a terminology. For example, in that case, normally when a client comes, just I give an example, restriction of conjugal right, suit for possession is to be filed, encroachment has been committed, this has been done, that has been done, some goods have been sold, payment has not been made, we issue a notice. Again, the principle is the same. We warn them, precaution, that they pay amount. If he pays, well and good, no suit is required to be filed. When he doesn't give, suit is required to be filed. So this is a legal notice what we talk about. The next is in that case is contemplated by law, and you must have come across that notice of lis pendens. In notice of lis pendens under section 52 of the Transfer of Property Act, what it contemplates that is just to again a caution. By this, what you do, you actually register the plaint with the registering authority so that entire world at large gets a particular notice that some suit or litigation is going on in respect of that particular property. Even though section 52 of the Transfer of Property Act contemplates saying that that the outcome of the suit will be binding on the transferee during the pendency of the suit. But still you make, because what happens that this will go on creating third party interest again and again, which will make consider into multiplicity of the litigation. So in order to stop that also you can file. The last which I feel in that case, very again according to the law, that is Transfer of Property Act, which can be styled as constructive notice. What is meant by this constructive notice? A constructive notice is a notice under section 3 of the Transfer of Property Act. Up till now, we have considered that actual act of giving notice is done. Either way, whether it is a statutory notice, contractual notice, public notice, lis pendens, legal notice, actual notice has been given. But in case of constructive notice, actual notice is not given. Constructive notice has been defined in section 3 of the Transfer of Property Act. We say that whenever any transaction in respect of immovable property worth 100, then the law presumes that the entire world at large has a notice of that particular transaction. This is the meaning of constructive notice, which is also a sort of a statutory, but it is not actually given. Therefore, I say it's a constructive notice. And even the word itself is that. If you see the judicial decisions or the commentary, you will find it is known as constructive notice. Law presumes that has been given, though actually not given. Therefore, what is the responsibility of the lawyer? Take example, a client comes to you and wants to purchase the property. Then what you advise him? You advise him what? If your client wants to purchase a particular immovable property, what advice you give? Paper notice I just told you. Public notice I just told you. Search and title. Why you take a search and title? You go and search and take a search of 12 years, take a search of 30 years of a particular property, of the documents which have been registered in the office of sub-registrar under the Indian Registration Act. Section 17 and Section 18 of the Indian Registration Act contemplates which documents are compulsory required to be registered, which documents are not compulsory required to be registered. And it says that well, property worth 100 rupees, immovable property, and when it is being transferred, surrendered, assigned, creating certain right, it is compulsorily required to be registered. And effects of it has been contemplated in Section 49 of the Indian Registration Act. Therefore, when law contemplates it is compulsory required to be registered, you are required to register it. Now, Section 3 says, in any case, any particular document which is compulsory required to be registered regarding the transaction of immovable property in so and so particular manner, then in that particular case, law presumes that there is a constructive notice to the entire world at large. And anybody dealing with that property has to get it, search, find out title, etc., as to whether there is any transaction. For example, in that police you come across, and particularly it happens in so many cases. Maybe mistake of lawyers, maybe mistake of any other particular person, solicitor, whatever it may be. Property is already mortgaged. What defense we can take, certain I can tell you, but still that defense becomes very lame. A client came to me, very high, doing in IT, getting lot of salary, etc., and purchase a flat in a property, and that builder has already mortgaged the entire property to a particular bank, which was not disclosed. He purchased a flat, and one day he received a notice from the bank attaching that particular flat. He came to me, he said, "Sir, I have not taken any loan, I have not particular person, there is no proceeding against me." I say, "Law doesn't require. Have you taken the search?" He said, "No." When I went to my lawyer, he said that, "Well, yes, all clauses are ठीक है, agreement," and you enter into an agreement, he entered into an agreement, and this notice has been received. Then we found out the bank has specifically stated and that mortgage was already registered in the year 2006. And he purchased the property in 2009, 2010. He was completely cheated and deceived by the builder. Flat, all these 4 or 5 flats were already mortgaged. Now, what is it? Bank said, pay an amount. What is the concept of the mortgage, my friends? Mortgage itself contemplates that mortgagee can chase any transferee. Transferee can't say that, well, you can't come to me. And that is what exactly the concept of the mortgage. Sometimes the only exception is that, well, if it is an equitable mortgage and if it is not known. But provided that you have to point out that your client, that is a purchaser, is a bona fide purchaser. And you know the concept of the bona fide purchaser. Everybody understand the concept of a bona fide purchaser? Or not? Concept of a bona fide purchaser. Everybody understands? Should I proceed further? Because you know silence amounts to acceptance. If you will not say, ask anything, I will presume that you know everything in that case. So therefore, my friends, the taking of a search, finding out the title, why this is the stage? I think there is one lecture also on this point. So this is what a very much important aspect, my friends. Even in case, sometimes in case of movable properties also, right? Because concept of mortgage does not apply to the movable property. But suppose there is already a loan taken on the car. Car is hypothecated, never say mortgage. The borrower doesn't disclose it. And he sells you at a very cheaper rate. Altis, original value 14 lakhs, selling it for 3-4 lakhs. The purchaser becomes very happy, used car for only 2 years, gets the car, within 6 months notice from the bank comes that he has taken a loan, hypothecation, etc., etc. Then bank says, you can use it, pay the loan amount. See, my friends, the concept is against when we talk about the notice and constructive notice, etc. Law presumes that you have got knowledge. This may not be strictly applicable in case of movable properties, but there are certain other parameters also. So therefore, friends, when we talk about the constructive notice, then it has to be taken into consideration from that angle. I think that very important aspects generally which a lawyer comes across, which I all told you. Then while drafting of a notice, what important aspect to be taken into consideration? Again, there is a drafting of a notice also. And I told you that lawyers take it very easily. I have seen the lawyers. I don't want to blame it. But whatever client tells, they just go on writing and send it. That is not the requirement, my friends. When you are issuing a notice, you must be entirely aware of the substantive law. And now here the connection of the notice and pleading I tell you. If you are not taken into consideration certain aspects, see my friends, when we consider in the drafting, pleading of a plaint, we talk about drafting or pleading of material facts. What is this concept of a material fact? Let us take an example. I will give it to you that way. Two examples which junior lawyers committed, then came to me and say that, sir, please save us from this. See, person having a large property, he was unsoundness of a mind. His father, he has the only son who has unsoundness of mind. He had issued a power of attorney in one of the trustee company, renowned company from Satara. They were collecting there merely 60 tenants and huge rent was coming. This unsoundness person died. Power of attorney automatically came to an end. He had only one daughter, and that daughter also not knowing everything. Her husband, that is the wife and the husband came to their case, had gone to particular lawyer. They said that, even though that their father has died, still that trustee company was recovering the rent and not allowing them to enter or look after this. The lawyer issued a notice to the trustee company that power of attorney has come to an end, etc., etc., etc. And very lightly stated, you will not hand over the management and the possession of the property. We'll have to file a suit against you for recovery of the possession and so and so, so and so and so. Suit came to be filed only for a declaration on 1,000 rupees, 100 rupees, declaration and injunction. When an injunction asked for, a senior lawyer came against him. He said that, all right, we can understand power of attorney has come to an end, but basic present suit is what for? Declaration and injunction. There is no relief of possession. I am still in possession. It has created, power of attorney has created right, title and interest. We are in possession. How injunction can be granted against us? The judge asked the junior lawyer, how can you ask for the injunction? He came running to me, sir, this blunder I have committed in notice, saying that, that you are in possession and we are required to file a suit for possession against you. He says, sir, what can be done? Then I say that, I thought over it. Immediately I also couldn't, I spent 3-4 hours and then I say that, you argue on that point. He said, sir, you come and argue. All right, I will argue on the temporary injunction application. The judge said, Kanitkar, why you have come for this? I say, sir, that there is a difficulty and therefore I am coming. He said, all right, what is the point? I say, sir, that there are two aspects. Admission of a fact and admission of a law. I could do it in therefore another was, but every time it may not be possible. I say, there can be an admission of a fact, but there cannot be an admission of law. Law is law. When I admit, I don't admit it. Law is there. Just said how it is applicable in the case. And I say, what is mean by relationship of a principal and agent? It has come to an admittedly. Now, if you have studied in the jurisprudence the concept of the possession, immediate possession, jural relation possession, you have considered this. For example, if I give this my coat to a laundry wala, Who is in immediate possession? The laundry wala is in possession. I am in not immediate possession, but immediate in possession. When he has to give back that coat to me, just like a wristwatch, I give it for repairs. He can't say he is in possession, file a suit for possession. He can't say like this. Therefore, I say, judge immediately got it. Thanks that this judge is very, very clever. He could understand the concept of possession, jurisprudence, everything. Then I said that, well, possession of agent is the possession of principal. In fact, possession of the principal is the possession of agent. Moment agency came to an end, he has no authority to enter on my property. So what my learned friend has stated in the notice in admission of law, which is not binding on me, just granted in things. See, my friends, coming back to the point, but sometimes we commit a blunder. But this blunder was committed, and there was no any other go but accept the particular contention that, well, and that is required to amend the plain vastly, which came to be rejected, we are required to come in the High Court. See, suit for partition. See, the blunder committed in notice. And what happened? One of the brother issued a notice saying that, well, this is a joint family property. I got this much share. You are not giving any share to me. You are allowed to file a suit for partition. He filed a suit for partition. And during the course of this particular pleading, etc., it was transpired without making inquiry, without understanding the law, the notice was given. It was transpired that, well, originally the property was standing in the name of that particular brother only. But later on it was found out, well, this was purchased by the father with his son, because that particular boy was in what was 16 years old. He had no purse. So that was a property purchased with the funds of the joint family property, or property purchased by the father for the benefit of the family, coming out of the clutches of Benami Transaction Act. You know Section 3 and Section 4 of Benami Prohibition Transaction Act. You can't take the defense. That is the law of Benami Transaction. You can't say, because the law says property standing in the name of that particular person belongs to him only. Only exception under Section 3 and Section 4. Therefore, I say you have to say that, well, property was purchased by the father. But that was not the notice, that was not the pleading. When he tried to lead the evidence, court say that, well, evidence cannot be laid beyond the pleading. You cannot lead the evidence. If you cannot lead the evidence, you know the fate. Notice is taken very lightly. So therefore, my friends, it has a connection with the pleading. Even I say, I tell my juniors, I tell my even this faculty of the students, say that, well, no, you must treat the notice as a plaint. Everything must have been considered at the time of filing of the suit itself. What is the law on that point? What are the judicial decisions on that particular point? That is what we talk about, the substantive law. A lawyer must know the substantive law. See, and that is the fate of conveyancing, you know that well. In some taluka places I have gone for lectures, I have found that well, you know that well, the bond writers sitting with the desk in the corridors of the court, clients are telling him and he is writing the particular ghankhat. गहाणखत का गहाणखत कुणाला माहिती तो म्हणतो आणि तो गहाणखतचा गहाणखत करून टाकतो तो. He doesn't understand the principles of the mortgage under Section 58 of the Transfer of Property Act. काही लिहून जातो. काही लोक लिहितात उलट खरेदी खत. अरे उलट खरेदी खत कुठलं? त्याला मग कन्सेप्ट कुठला आला? ज्याला आपण म्हणतो मॉर्गेज बाय कंडिशनल सेल. मग त्याच्यात काय आहे? तो दोन लिहितो खरेदी खत आणि which law says cannot be. एक पहिलं गहाण खत लिहितो आणि दुसरं तो उलटून खरेदी खत. दोन दोन डॉक्युमेंट करतो आणि तो सांगतो ठीक. आणि दीज आर द बॉन्ड रायटर्स. आवर क्लायंट्स गो, इवन लॉयर्स से द्या आमच्या त्या क्लार्ककडे लिहून घ्या. आय हॅव सीन इन तालुका प्लेसेस समटाइम्स रिटर्न स्टेटमेंट इज बीइंग फाइल्ड बाय द कारकून, दॅट इज बाय दिस पर्टिक्युलर डिफेंड. त्याला काय एवढं माहितीये? हे खोटं आहे, गळीपडूपणाचं आहे, सगळं असं आहे. गळीपडूपणाचा तर डिफेन्स कायम असतो पाहिजे. हे खोटं आहे, बनावट आहे, दादांत खोटं आहे, एवढंच, बाकी काही नाही. पॅर नंबर मधलं खोटं आहे, दादांत आहे. व्हॉट इज युअर डिफेन्स? In written statement, the defense must come. If you see the scheme of Order 8, Rule 2, 3, 4, 5 of the CPC, mere denial or image denial is not a denial at all. It is deemed to have been accepted, and we write exactly reverse. My friends, so therefore, at the time of drafting the notice itself, you must study everything, substantive law, and therefore it has got a connection. It is as good as a plaint. You should treat it as good as a plaint, so that all the parameters will be covered. That is most important. I had gone conducting one appeal in the Baramati court. Matter was remanded by the High Court. On one particular ground I could succeed. I will tell you during the course of this. See, my friends, I am not boasting myself. I am just pointing out where we lack sometimes. So, friends, you will find that, well, when you are drafting a notice, take proper instructions. Take proper instructions from your client. And if interview with your client. In fact, I say the persons who are practicing at the trial court, what we talk trial court advocacy, interview with the client or taking the instruction from client is very most important. In High Court, appellate side खालनं सगळं तयार होऊन आलेलं असतं. पण इथं तुम्हाला you have to build the castle. Trial court advocacy is very much important, my friends. तुम्हाला you have to build up the case. And when you have to build up the case, you have to make out everything. And use the language also properly. I will give one example. मग आपण काय म्हणतो नोटीस? आपल्याकडे लेटर हेड असतं, घेतो नोटीस. सगळ्यात बॉडी ऑफ द प्लेन फार महत्वाची असते. And you are not a particular own person. You are giving a notice on behalf of your client. काही वेळेला वकिलांना ते सुद्धा लक्षात येत नाही. When I was chairman, I was required to 2-3 conduct cases like this, and even from city. One case was from Thana, one case from other side. Restriction of conjugalची नोटीस दिली होती. वरती लिहिलंय सगळं ऑन बिहाफ ऑफ माय क्लायंट एक्सेट्रा एक्सेट्रा. आणि बॉडी ऑफ द प्लेंट मध्ये advocate is giving notice, and what he is writing? You are not residing with me. You are not cohabiting with me. All these particular notice was given. आवाज गेलाय का? मागणं आवाज सुरू होईल लगेच. आलाय ना? ऐकू येते? आचार्य अत्रे एकदा आम्पी थिएटर मध्ये फर्ग्युसन मध्ये लेक्चर देत होते आणि त्यांनी आवाज दिला. मीच मागे जात होतो, सज्जन हो. ते मागणं लोक काही म्हणाले की अहो आम्हाला काय ऐकू येत नाही. ते म्हणले मी फक्त सज्जनांसाठी बोलतोय म्हणले. जोक अपार्ट्स माय फ्रेंड. फ्रेंड्स, लॉ हा इतका काही लोकांच्या दृष्टीने रटाळ आहे, पण इट कॅन बी मेक इंटरेस्टेड. तुम्ही कोर्टात आर्ग्युमेंट करताना सुद्धा एका स्टोन मध्ये एकाच ह्याच्यामध्ये सर इट हॅज हॅपन लाईक दिस, तुम्हाला यू हॅव टू मेक द जज इंटरेस्टेड. त्याला फॅक्ट सांगताना असं वाटलं पाहिजे किंवा की शेवटी मी ह्याला काय रिलीफ देऊ, किती रिलीफ देऊ. एक्झॅगरेशन नाही, ड्रॅमॅटिझम नाही, पण थोडाफार त्यातला भाग येतो. मला आठवते माय फ्रेंड्स, एका 1.5 वर्षाच्या मुलाची आई घेऊन आली पाडव्या दिवशी आणि मला म्हणाली माझं मुलगं माझ्या नवऱ्याने काढून घेतलंय. आता मुलांनी काढून घेतल्यानंतर, नवऱ्याने काढून घेतल्यानंतर काय रेमेडी आहे? फॉर्च्युनेटली फॉर मी मे कन्सिडरिंग होता. म्हटलं मॅरेज पिटिशन काढून कस्टडीसाठी अर्ज करून केव्हा होणार? 5 वर्षाच्या खाली मुलाला कस्टडी आईकडे पाहिजे, पण कशी ती मिळणार? किती वेळ लागणार? आणि ती सारखी रडत होती आणि ती म्हणत होती सगळं अजून तो पिता आहे, स्टील ही ब्रेस्ट फिडिंग आहे, आणि सारखं जसं काही मीच काहीतरी गुन्हा केल्यासारखं म्हणत होती माझा सोन्या मला द्या. अहो म्हटलं माझा सोन्या तुमचा देतो, पण म्हटलं तुमचा सोन्या मला द्या. म्हटलं लेट मी ट्राय फॉर इट. मग दुसऱ्या दिवशी मी सेक्शन 97 खाली अर्ज केला, 97 CRPC, की टू ब्रिंग दॅट चाइल्ड इन दी पर्टिक्युलर बिफोर द मॅजिस्ट्रेट. आणि त्याच्यामध्ये एक क्लॉज आहे की इफ अदर साइड हॅज कमिटेड अन ऑफेन्स, आता here I was pointing out the offense of a kidnapping, the manner in which the child was taken. आम्ही सगळं लिहिलो त्याच्यामध्ये, फार वेळ न घेता सांगतो त्याच्यामध्ये. मग शेवटी मी असं म्हटलं की that offense of kidnapping has been done. The magistrate asked me, Mr. Kanitkar, how that is a kidnapping? Fortunately, I could get a judicial decision. It was a judgment of Shimpi from Nagpur bench. Even a father can also commit an offense of a kidnapping of a child. पण मी सुरुवात अशी केली सांगायचं मध्ये म्हणले, सर, it's a very unfortunate child which has been brought before this honorable court. I don't think what will happen if the custody has not been given at the end of the day. One doesn't know whether doctor will be required to be called here. मॅजिस्ट्रेट म्हणजे काय झालं सांगा सांगा. मी म्हटलं आता कस्टडी मिळणारच आपल्याला त्याच्यामध्ये. आणि देन वी पॉइंटेड आउट ऑल दीज थिंग्स सेज 1:30-2 वाजता त्यांनी कस्टडीची ऑर्डर केली. सी माय फ्रेंड्स, लॉ हा इतका विषय विचित्र आहे की म्हणून याच्यामध्ये लॉ मध्ये आता तो आजचा सब्जेक्ट नाही पण आम्ही नेहमी सांगताना सांगतो की व्हॉट इज मीन बाय ॲडव्होकसी. वकिली म्हणजे तरी काय? नॉट ओनली नॅरेटिंग द फॅक्ट्स, not only narrating the law, but you have to make this particular judge understand. You have to know your judge. जज जर हुशार असेल तर त्याला फार शिकवायला जाऊ नका, नाहीतर सारखं त्याला शिकवायला गेल्यानंतर तो म्हणतो मला नका शिकू, मनात म्हणतो, तो तोंडावर म्हणत नाही. पण ज्याला काहीच कळत नाही त्याला तुम्ही असं कळ गेला असाल, मग त्याला तुम्ही कशा पद्धतीने सांगायचं? अपार्ट फ्रॉम दॅट, कमिंग बॅक टू द पॉइंट, ही तुम्हाला ते सांगितलं की नोटीसमध्ये अशी चुका करून जातात. आणि मग देन झालं तर वेन आय वॉज अ चेअरमन द मॅटर ऑफ इन्क्वायरी केम टू मी अँड दॅट पर्टिक्युलर क्लायंट रोट ए लेटर, फाईल अ कंप्लेंट अंडर सेक्शन 35 की हा मला म्हणतो की बाबा की तुम्ही माझ्याबरोबर राहत नाही, तुम्ही माझ्याशी कोहॅबिट करत नाही. मग मी माझ्या लक्षात आलं की दिस इज अ मिस्टेक ऑफ ए लॉयर वाईल ड्राफ्टिंग द नोटीस. सी माय फ्रेंड्स, व्हॉट ए ग्रॅव्हिटी देअर. when you are drafting a notice, several aspects are there in that process and therefore find it out. आणि दुसरं एक सांगितलं की हाऊ इट इज अ कनेक्शन विथ द प्लीडिंग अँड दॅट प्लीडिंग आय टोल्ड यू दॅट वेल यू मस्ट कव्हर एव्हरीथिंग इन नोटीस. काय वेळेला असं होतं कनेक्शन जरी नोटीस इज नॉट प्लीडिंग स्टील होतं कसं? सपोज यू आर स्टेटेड सर्टन पर्टिक्युलर फॅक्ट इन द नोटीस or not stated certain fact in the notice, and for example between landlord and tenant, landlord files a suit against the tenant on the ground of bona fide requirement and all the particulars have not been given, and when the suit has been filed certain contentions have been taken. The question will come in the cross examination, when you gave a notice why this has not been included in the notice? It is an afterthought. See, there are so many aspects are there, and therefore you have to always see that the connection between notice and a pleading. I think I have given a sufficient message for that aspect. This is what about talk about the notice, my friends. My friend, that will take me to the pleading, drafting and pleading in that case. Now, friends, when we talk about a drafting and pleading, and particularly we are talking about the civil pleading, several aspects need to be taken into consideration. But like several aspects need to be taken into consideration. Friends, those who are practicing at criminal side must have understood that well, in criminal matter there is no much drafting. Criminal law can be set in motion by any person. It's very easy to set the criminal law in motion, particularly in case of cognizable offenses. You can just go, if you see the provisions of section 154 of the CRPC, first information report, there is no much drafting and etc. Police will do it, provided the police is honest and he is taking the cognizance. Otherwise, nowadays, exactly reverse. The reporter becomes a particular victim in that case. Apart from that, if you lodge a particular FIR, law is set in motion, ball is set in motion, and the criminal law will take its own course. He will send the report to the magistrate, magistrate will issue, etc. Everything is there. In case of cognizable offences, such is not the case in case of non-cognizable offence, where they are required to draft a private complaint under section 194, 94, 95. You are required to draft a criminal complaint, but that is not part in that well. But in civil law, how a civil law can be set in motion? A civil law can be set in motion only by presentation of a plaint. And that is the provision in section 26 of the Civil Procedure Code. What section 26 says that, well, a suit can be said to have been instituted by presentation of a plaint. So unless you present a plaint, suit cannot be said to have been instituted. So institution of a suit is by presentation of a plaint. So section 26 is the starting position by which you can set the civil law in motion. You have to present the plaint and you can set the civil law in motion. So when we talk about the plaint, then wording section 26 says, by presentation of plaint in the manner laid down. And what is the manner laid down? The manner is order 4 of the Civil Procedure Code. So section 26 has to be read with order 4, rule 1, 2 and 3 of the CPC. This is what the procedure contemplates. Order 4 contemplates manner, but it has to be also understood for some another purposes, and therefore you have to take into consideration that particular aspect of order 4 read with section 26. Now what is mean by plaint? Plaint has not been defined anywhere, my friends. Plaint has not been defined in the Civil Procedure Code. But plaint means what? If we see the position, the plaint means nothing but a private memorandum drafted by the lawyers or a particular party. It's a private memorandum incorporating